response to the complaint is the defendant will either answer the complaint, in which he'll say, yes, I affirm you do have jurisdiction. Yes, I affirm these are the parties. No, I do not affirm the facts. Or, yes, I affirm that the elements of trespass is X, Y, and Z, but I deny that the facts of X, Y, and Z support these elements. Of course, you can also say don't know. So the defendant might file an answer which might include affirmative defenses, affirmative defenses are defenses that, the easiest way to think of them are, well, yeah, I did that, but I can. Trespass has an exception that you can trespass if there's an emergency and you're trying to prevent harm of another. So the affirmative defense might be preventing the harm of another, and then might list the facts. I was carrying a sick child and I needed to cut across the property in order to get to the hospital faster. Well, so he's admitting to entering the property of another. He's admitting to it, and he's saying, so what? Because I was carrying a sick child on my back. And that makes me free to do that. Might raise a counterclaim. Oh yeah? Well, I disagree that I trespassed, but you know what? I did fall in a hole right by his property, which had a sign that said, that made it seem that the owner of the property was the one that dug the hole. And since the property owner should have known that people traveled along that road, he should be responsible for my medical bills. So I'm going to counterclaim him for negligence. Can also file motions. We'll talk about some of those motions in a second. If no answer is filed within the allotted time, then there will be a default judgment. The presumption will be that if you don't take the time to answer the suit, then you must agree to the liability that the relief that the plaintiff is asking for. If you don't even take time to say, whoa, this isn't what happened. If you don't take the time to do that, then you're screwed. You'll get a default judgment against you. And that's why it's important never to ignore legal filings against you, because the court will go on without you if you're not there. After the complaint is filed, and the answers are filed, we'll go into the discovery stage. This is where further investigation occurs. And there are multiple types of investigations. There's interrogatories, where basically written questions to opposing party. and usually there's a specific number that are allowed, and it depends on what state it is. There are depositions, asking questions, and that could also be in writing, but it's simply, where were you in May, whatever date, why were you there, did you cross onto the owner's property, the opposing party's property, request for admissions. These are perfunctory things that you just want to get out of the way, that you think are likely to be admitted by the opposing party. Document production. Also known as subpoena ducis tecum. And we'll talk about that later. Could also request medical, physical exams. So these are general types of discovery that you might see. You might also see motions to compel. If the requests are being refused, then the party can ask the court to force the other party, and that request is through a motion. Your Honor, I move to compel the defendant to produce the documents I've requested. On the other side of that is a motion for a protective order. Your Honor, the documents that are requested by the defendant or by the plaintiff, they're attorney work product. They were put together in preparation for this lawsuit, and it's just not fair to hand it over to them, hand over the game plan, basically, to the other party. So you can move to protect that information, or otherwise protect sensitive information, or information that would just be too difficult to compile and unnecessary in general. After discovery, move on to pretrial. Pretrial conference. And there's a meeting before discovery where the attorneys come together to figure out exactly what kind of discovery is going to be sought. And then you'll have several conferences through the process to try to clarify the issues, the defenses, what witnesses are going to come before trial, what kind of exhibits are going to be shown. Also, if a settlement is possible, that's going to be tried at every stage. Then you're going to have motions in limine, which are motions right before trial that an attorney is asking the judge to make a decision on. So, for instance, you don't want certain evidence that would just be ridiculously prejudicial, that would sway the jury in a way that just doesn't make sense. Kind of like the smoking gun evidence that really isn't that smoking, but it really looks like it is.